Good afternoon, everyone. As promised, today I am going to talk on PCPNDT Act. So, basically, this act was initially enacted in the year 1994. When it was enacted in the year 1994, it was named as the PNDT Act, uh, Prenatal Detection and Termination, Regulation and Prevention of Misuse Act. Later on, when it was enacted, though it was applicable throughout India, it was not strictly followed. So, in the year 2000, this association, which is called as the CHEHAT, this is a Pune-based NGO. This association filed a case in a Supreme Court for the strict application of this act. So, this case was started in year 2000 and ended in the year 2003. And meanwhile, in between, according to the directions of the Supreme Court, in the year 2002, this PNDT Act was uh, amended and it was renamed as Preconceptional and Prenatal Detection and Termination, Regulation and Prevention of Misuse Act 2002. And the same name was given to the retrospectively given to this Act of 1994. And meanwhile, when this Act 1994 was enacted, according to the provisions of this Act, these PCPNDT rules were made in the year 1996 and after that in the same year. So later on, what happened? These rules were also amended according to the requirements, and this amendment is still going on. So the main it was amended in the year 2014 also. Again, uh, uh, various circulars were also issued according to these rules. So we will see all these rules step by step. So there are two methods of studying laws related to medical practice. First method is how we can study the law according to the practice of according to our medical practice, means how we practice the medicine and which law are applicable at which stage. And second method is to study the law according to the how it is or how it is evolved. So in this lecture, I am going to tell about the law according to the its evolution. So these are the definitions which are present in this law or in this Act, PCPNDT Act. Some important definitions are the definition of conceptus, which means routinely which we call as the product of conception. Again, there is a definition of embryo. According to that definition, any product of conception, conception POC till the 56th day of its conception is called as the embryo, and later on it is called as the fetus. And there are the various categories which are defined as genetic counseling center, means a place where genetic counseling is done. Again, there is one more uh, category which is called as the genetic clinic, means any place or vehicle. So why vehicle is introduced? To give recognition to the mobile units, mobile scanning units, USG units, vehicle where the prenatal diagnostic procedures were conducted, including USG imaging or scanning. Again, there is one more category which is called as the genetic laboratory, means any place where the analysis or the test of sample received from the genetic clinic for prenatal diagnostic test are conducted, including USG imaging center and scanning center. So you can see that the USG center or imaging or scanning center comes in the category of genetic clinic or genetic laboratory. And there is a provision for the mobile USG unit also. So later on, there is a definition of gynecologist. according to which a person who possesses a postgraduate qualification in gynecology and obstetrics is called as the gynecologist. So later on, one circular was issued, which according to which the persons who are DGO, they are also considered as the gynecologist. Again, there is a one terminology which is called as the medical geneticist, means a person having a degree or diploma in genetic science or at least 2 years in the field of sex selection and prenatal diagnostic techniques, and any one of the medical qualification recognized by the MCI Act 1956, means a MBBS doctor, means a MBBS doctor who is having degree or diploma in genetic science or who has at least 2 years of experience in the field of sex selection and prenatal diagnostic technique. And apart from this, a postgraduate degree in biological science is also sufficient, means a MSc biology in any in biological science. Again, there is a one more definition which is called as the pediatrician, a person who possesses the postgraduate qualification in pediatrics. So it in postgraduate qualification means MD or DCH or DNB. Again, a sonologist or imaging specialist is also a person who possesses any one of the medical qualification recognized under the Indian Medical Council Act and who possesses a postgraduate qualification in ultrasonography or imaging technique or radiology. Means a MBBS, and after that a MD radiology or DMRE or DMRD. Again, this is a section 4 which says that regulation which is related to the regulation of prenatal diagnostic techniques. So according to this section, there is a prohibition on use of any registered center, means with genetic counseling center or genetic laboratory or genetic clinic for prenatal diagnostic test or procedure except in accordance with the provisions of subsection 2 and 3. Means any center or any sonography center have to perform the test and procedures in according to these provisions which are prescribed in this subsection 2 and subsection 3. And these provisions are this procedure or test can be conducted for chromosomal abnormalities, genetic or metabolic disease, hemoglobinopathies, sex-linked genetic diseases, congenital anomalies, and any other abnormalities or disease as may be specified by the Central Supervisory Board. Means according to this section, this power was given to the Central Supervisory Board. And which is this board? This board was enacted, Central Supervisory Board was enacted according to the provisions of this Act. These provisions are in the upcoming sections. Again, this is a subsection 3, according to which any prenatal diagnostic technique. So you can see that here the word technique is used, and in this test and procedure is used. Means test and procedures are done at sonography center, while techniques are done at some invasive procedure. Techniques are some invasive tests. So this should be done if only if the age of pregnant woman is more than 35 years of age, the pregnant woman has undergone more than one spontaneous abortions or fetal loss, the pregnant woman had been exposed to potentially teratogenic agents like drug, radiation, or infection or chemical, or the pregnant woman or her spouse has a family history of mental retardation, physical deformities like spasticity, or other genetic disease, or any other condition as may be specified in by the Central Supervisory Board. See, again, the power were vested in the Central Supervisory Board. But there is a one most important provision in this section which says that any person who is conducting USG of a pregnant woman should keep its complete record, and in case of deficiency or inaccuracy in it, it shall be presumed that as a contravention of provisions of section 5 or section 6 unless contrary is proved. This is the most dangerous section for us, provision for us, because why? See, according to this section, it is compulsion on a doctor conducting USG to keep the record in the prescribed format, and if that doctor fails to prescribe to keep that record or any deficiency in that format, it will be presumed at the contravention of the provisions of the section 5 and section 6 unless contrary is proved. Means suppose a doctor is supposed to keep the record of a woman while doing sonography in a form F, And if there is any deficiency in Form F, means there was a signature was not missing, or the name of that woman was missing, or the address of that woman is missing, then what will happen? It will be presumed by the that authority or court that it is the contravention of the section 5 and section 6 unless contrary is proved. Means what happened? There is a one provision in the evidence law that burden of proof. Means what is meant by burden of proof? Burden of proof means who will prove the allegations. So there is one concept that the party, if no evidence is given on the both side, then which party would fail? That party will prove that allegation. But in this case, it is opposite to that concept. Means we have to prove our innocence. And what is section 5? Section 5 says, is about the written consent of pregnant woman and prohibition of communicating sex of a fetus. So what it says, subsection 1 says that prenatal diagnostic procedure shall not be conducted without explaining all known side effects and after effects of the such procedure to the pregnant woman concerned, obtaining her written consent in a prescribed form in her own language. This own language is also important. Generally, what happens? We take the consent in the English, Form F, which is written in our PCPNDT Act, and it is in English. And generally, what happens? We take that consent in the English. So, what is expected? We have to take that consent in that woman's her own language and in prescribed forms. That forms are prescribed by the authorities, which we will see later. Again, giving a copy of consent obtained in a prescribed form to the pregnant woman means what we have to do? We have to give the copy of that prescribed form on which her consent is taken to that pregnant woman. Generally, we don't give such copy. So what is expected from us? We should fill that form completely, which is in her own language. Take her own signature, take her signature, and take a receipt also on that form that she has received one copy. So if even in the absence of such received copy, you will be considered as a guilty. And second thing, the sex of the fetus by words, signs, or in any other manner shall not be communicated to the pregnant woman concerned or her relatives or any other person. So what will happen if there is any deficiency in doing these things which are prescribed in section 5? So that will be considered as the you are doing sex detection. This is a section 6 which says that prohibition of sex determination. So any genetic counseling center or genetic laboratory or genetic clinic should not conduct in its premises prenatal diagnostic techniques including USG for the purpose of determining the sex of the fetus. Again, the person should not conduct any prenatal diagnostic techniques including USG for the purpose of determining the sex of that fetus. Means doing these things at the center are also prohibited, and doing these things by the person is also prohibited. Means what happen if that owner of the center is different person and the radiologist is a different person, then according to this section A and B, both will be considered as the guilty. Means if owner cannot claim that he don't know that, and this sex determination is done by that person or that radiologist who is the employee, so this defense will not work. Again, person should not cause or allow to be caused selection of sex before or after conception, and any other person means relatives of the patient are also included in this list. So what happened if we fail to prescribe that record in a prescribed format, then it will be considered as you are doing the sex determination. Means strictly it is written that deficiency in keeping record will be considered as the contravention of the provisions of 5 or 6, and we have seen what is written in the section 5 and section 6. So this is why the keeping record properly is important. Again, this is related to the application of the registration. So what it says, prohibition on opening of the center or laboratory or clinic unless registered, means unregistered clinic, which are the clinics or centers or laboratories which are not registered under this act are prohibited from opening such center, and such center should not be opened. Again, the center, laboratory, or the clinic shall not be registered under this act unless the appropriate authority is a district authority is satisfied that it is in a position to provide such facilities, maintain such equipments and standards as may be prescribed. Again, this is related to the registration certificate, which is section 19, which says that appropriate authority, on being satisfied after taking advice of advisory committee, will issue registration in the prescribed format. So in the sections from 7 to 17, there is a provision related to the constitution of the appropriate authority, central supervisory board and state supervisory board and district advisory committee. So, and appointing the appropriate authority. So generally, who is the appropriate authority? Appropriate authority is a civil surgeon at for district level, and a chief health officer of a municipal corporation in a municipal corporation area. So that authority, on being satisfied after taking advice of the advisory committee, will issue the registration of the registration certificate in prescribed format. So whenever we apply, we have to wait for the meeting of the advisory committee. Why it is necessary? Because according to this provision, before issuing a registration certificate, that civil surgeon or that health officer has to take the advice of that advisory committee. Again, if appropriate authority, if unsatisfied, can reject the application for registration after giving an opportunity of being heard and after taking advice with stating reasons for the such rejection and prescribed format. Means if appropriate authority feels that, and that the provisions of this act are not satisfied or are not complied by that applicant, then it can, after giving an opportunity of being heard to that applicant and after taking the advice of the advisory committee and with the stating reasons for the writing, can reject the application format in a prescribed format, and that prescribed format is prescribed letter. We will see that what is that prescribed format. We will see it later. Again, renewal of registration as prescribed. So according to this act, the provision for renewal of registration is said that as prescribed, according to the prescribed process. What is that process? It will see, we will see it later. Again, registration certificate should be displayed at conspicuous place at the center or that laboratory or that clinic. Again, these provisions are regarding the cancellation or suspension of registration certificate. Again, this is the appropriate authority on suo motu, means on its own or on a complaint, may issue a show cause notice asking why its registration should not be suspended or cancelled for the reasons mentioned in the notice. See, means whenever appropriate authority feels that, or whenever that appropriate authority receives the complaint against you, that will issue a show cause notice asking why your registration should not be suspended or cancelled for the reasons mentioned in this notice. So grounds for that cancellation. And after giving an opportunity of being heard and on being satisfied, for such appropriate authority may suspend or cancel the registration. Means after hearing your side and after being satisfied, appropriate authority can cancel your registration. And here, this is a provision in subsection 3. It is stated that appropriate authority may cancel or suspend the registration without serving notice and without giving opportunity of being heard by stating reasons for doing such. Means that authority has a power to suspend your registration without giving you an opportunity of being heard or without serving you a notice. Again, what we can do? We can appeal against this order under this section, and appeal against this order of cancellation or suspension of registration can be made to the government, means to the health ministry, and related to state governments if that center is situated in state, and to the central government if that center is situated in the union territories. And appeal period is 30 days. It means we have to file the appeal within 30 days. Again, these are the offenses as punishment and penalties. Which is that offense? Under section 22, the offense is prescribed as any person who does advertisement of prenatal sex selection or determination, that person shall be may be punished up to the imprisonment up to 3 years, and fine may be imposed upon him which is up to 10,000 rupees. And again, this is section 23, subsection 1 and 2. The owner or the doctor who contravenes any provisions of this act may be punished with imprisonment up to 3 years on the first conviction and up to 5 years on the subsequent conviction. So there are various cases where the doctors were doing the same offense multiple times. So in this case, there is an enhanced punishment for the subsequent convictions, and at the same time, the fine for the first conviction will be up to 10,000 rupees, and for subsequent conviction, it will be up to 50,000 rupees. But there is one dangerous provision, according to which if the FIR is lodged, registered, and investigation is completed, and charge sheet is submitted, and charges are framed. So after what happen after registration of FIR, police submits the charge sheet to the court, and after when the police submits the charge sheet court, then the charges were framed on the accused. Means court say in the court says the accused that these charges are framed upon you, and do you admit the guilt or do you confess your offense? This process is called the framing of charge. So after the framing of that charge, this appropriate authority or the may request the medical council to suspend the registration for 5 years on first conviction and permanently on subsequent convictions. Means once the charges are framed till the disposal of the case, registration can be cancelled, and if you are acquitted, then the registration will be restored, and if the punishment you are convicted, then the registration will be suspended for 5 years and on the first conviction, and if you are and up to permanently on subsequent convictions. Means see what happen in this case, if the FIR is registered under this act and charges were framed, then the MMC has a power to suspend your registration till disposal of the case. Means if disposal is it is going to 10 years for disposal, then your registration may remain suspended for 10 years. Again, there is a provision for appeal against the order of MMC to the National Medical Commission also. Again, this is the offense related to the relatives. The person other than the pregnant woman who seeks the aid of for doing sex determination or selection, he may be punished up to imprisonment up to 3 years on first conviction and up to 5 years on subsequent conviction, and fine of 50,000 rupees for first conviction and up to 1 lakh rupees for subsequent conviction. Again, this is a contravention of such provisions of Act and rules for which no punishment has been prescribed. Means there is any other act which is a contravention of other provisions of Act for which punishment was not prescribed. The punishment will be up to imprisonment up to three months or fine up to 1 lakh rupees or both. Means here imprisonment is mandatory. But in earlier offenses, imprisonment is compulsory. That is imprisonment and fine. Again, Section 24 says that pregnant woman shall be presumed innocent unless proven guilty. Means she will be presumed innocent, and whereas the doctor who failed to keep the record properly will be presumed as the guilty unless proved innocent. So this is a difference, that pregnant woman will be considered as innocent and doctor will be presumed as the guilty. And the all offences under this act are cognizable. Means police officers are empowered to register the FIR. Non-bailable means the accused doctor cannot claim bail as a matter of right. Means he may have to remain behind bar till court grants the bail, which may take a week also. And the offences are non-compoundable, means mutual compromise cannot be done in such offences. And Section 28 says that only appropriate authority or a person who has given information to appropriate authority and authority has not taken any action on it within 14 days, then such person has a power to file a complaint, and only JMSC is competent to take cognizance of the offense. Means see what happened, police officer on its own cannot register the FIR. Either the complaint should be given to the police station by the appropriate authority, or that person, suppose any person who wants to complain against any doctor, he has to complain to the appropriate authority. Appropriate authority will do the investigation, or and later on appropriate authority will register the FIR. And if appropriate authority doesn't take any action within 14 days, then that person can approach to the JMFC. This is the proper procedure. So I came across one FIR where police officer on its own registered the FIR, and later on High Court cancelled that FIR. Again, This is section 29, which says that records should be preserved for at least 2 years or till the final disposal of the proceeding, if any, if there is any. Means every record you have to preserve it at least for 2 years, and if any proceeding is going on against you, then you have to you have to preserve that record till the final disposal of that proceeding. And again, section 32 says that power to make the rules. So the central supervisory authority or the central advisory committee has a power to make rules for the enactment of this act, which are consistent with these provisions of this act. So we will see these rules in the upcoming lectures. Thank you very much. Hope I have delivered some useful content to you.